All right, in this case, the son-in-law owned a house that he wanted to sell, but was unable to find a buyer. As a result, the son-in-law contacted father-in-law and said, hey, you want to buy the house? Father-in-law essentially said, I don't want to buy the house because I'm not sure I can rent it out. Whereas son-in-law and father-in-law said, look, we'll enter into a lease agreement. And they use it a standard form, wonderful residential lease agreement that you buy at Office Max or get on the internet. The relevant lease agreement terms are contained as follows. Okay, these are the standard form lease agreement terms. Monthly lease of $1,000. Father-in-law receives a 5-year option to purchase. Son-in-law was to be current in obligations pertaining to the property, and there's a 4 corners clause. Now, a 4 corners clause essentially means that the whole agreement is contained in the agreement itself. There's no other peripheral agreements to this document. So the entire agreement is contained in the written document. And that's really important. That is actually something that I typically, we've always put in our agreements, because you don't want all this other parole evidence, is what they call it, all these other agreements coming from other sources to come in and interpret your document. So that's something that we standardly put into our documents. And it also said, and this is something we put into our documents, is that if you amend this agreement, it has to be in writing. That's something that's standard in most agreements. Going on. There was a verbal agreement with this, which you gotta love, right? Son-in-law was in default of his mortgage at the time the lease was signed. The verbal agreement was that monthly payment was to be reduced, but father-in-law was unable to obtain a tenant for the full monthly mortgage payment. So essentially, father-in-law found a tenant. Tenant would only pay $800, so father-in-law went back to son-in-law and said, you need to make up $200. And son-in-law did that. Father-in-law performed repairs and improvements to the property. There was no formal written amendment ever signed between the parties evidencing the additional terms. All right. Relationship got bad, and bad things happen, otherwise we wouldn't be here right now, right? In September, son-in-law advised father-in-law that father-in-law was responsible for the full rental payment pursuant to the standard form lease agreement. That's what it said. Father-in-law refused to pay the additional amount. Son-in-law told father-in-law, get out, get your tenant out, and I'm going to sell the property. As a result of the father-in-law's breach. Father-in-law ceased making payments in September. Property was sold in February. Any questions on the facts so far? And son-in-law, of course, brought a wonderful lawsuit against son-in-law, or son-in-law brought it against father-in-law. Father-in-law counterclaimed for damages as a result of making improvements and those type of things to the property. Now I know this is really small, but this is kind of I'm giving you guys, I'm being fair this time. I'm actually giving you the facts here, if you can see them. So, what's the result and why? Let's kind of walk through this quick. What are the final terms of the agreement between the parties?
4 corners. It's all in the contract.
Okay, Shell says 4 corners. That's it. Verbal agreement doesn't come in, right? Right? That's what you're saying, right?
Not a 4-corner contract.
All right, all right.
Yeah, but couldn't that actually be another contract, the verbal agreement that they have?
But the verbal agreement pertained to the property specifically and about the lease payments and all those things. So it.
Is that what a 4 corners agreement does?
Yep, keeps everything.
So nothing in the future can be.
What's that?
So no future agreements can.
You can make future agreements, but they're supposed to be in writing. And in this case, there was nothing else.
Okay.
There was no other formal agreements in writing. So there's no, Jenny, what you're saying is absolutely 0 contract from the get-go, right? Everybody walks away, it's too bad, so sad, right? That's what you're saying? Okay. That's good.
But if it's sold, then if he sold it, then it was.
Right, and son-in-law sued father-in-law for the rent that was for the extra $200 that son-in-law paid to father-in-law during that period of time, and then also for the unpaid rent from when father-in-law terminated tenancy of the date of sale. That's what the damages that were claimed by son-in-law. Father-in-law brought the lawsuit for the improvements and the repairs and the value that he added to the property. So that's what the lawsuit was about.
Father had 5 years to buy that property.
So what I hear is either this is the agreement or there's 0 agreement. Is everybody okay with that? Was there any consideration for any changes to the lease agreement? Jan says no.
Nothing was in writing.
Jenny, you're saying no because there's no contract, right? Dave, you're saying no because nothing was in writing. Any other perspective on this? And so what did the court decide? Jenny, you said no contract. Shelley, you said 4 corners. And that's all, you guys are okay with both those answers, right? No new answers? Okay. Oops, I guess I gotta tell you. All right. In this case, what happened is the court actually decided that the contract was amended. And the reason the contract was amended is kind of goes back to what Jenny said. Number one is, he was already in default from the beginning. It wasn't that there was no contract, it was that he allowed actually additional evidence to come in. In addition, because he was paying these checks out, son-in-law actually was paying father-in-law these $200 checks a month, we argued that these $200 checks, evidence writing, right? Checks have to be writing, they're sent there, that modifies the agreement. Well, the court bought our argument there, so it was good, right? So ultimately what happened was, the terms of the agreement was that that $200 deficiency amount came in. Father-in-law had the right, had the option right, and continued to have the option right, which also came in. Father-in-law was compensated for the repairs because son-in-law sold the property. And essentially what the court said is, hey, son-in-law, you breached this agreement. Father-in-law didn't breach the agreement. Son-in-law, you breached the agreement because the agreement was amended and you didn't comply with the amended terms. My point on this, and the big thing in consideration, and this is actually a really good example, is a lot of times in business, what happens is, it's not necessarily whether the consideration is at the front end of a contract, because most of the times, there is good consideration on contracts up front. It's really when the contracts are amended or changed. Because a singular promise, when we go back and talk about the law on consideration, one promise, just I promise to give you, Sherry, something. There's no consideration for that singular promise. And a lot of times when you're amending an agreement, there is just a singular promise. And that's one of the things that, in that case, the court was trying to figure out was there additional consideration to allow for the amendment? And the court did say that there was consideration because of the fact, actually, that he was in default and the father-in-law allowed him to make up the payments, okay, because he had the obligation to make sure that he was not in default at the time the agreement was entered into. And that's the reason that you need to be very careful when you're amending agreements, that there is additional consideration to support the amendment, because otherwise the amendment may actually not be void, it may be void.